Hi everyone, today I'm going to walk you through how a dispute is resolved in the ICAC, the International Commercial Arbitration Court, in a simple and practical way. At first, arbitration might sound complex, but in reality the process follows a clear structure. First, before any dispute even starts, everything depends on one small but very important detail: the arbitration clause in your contract. This is the part where both parties agree in advance that if something goes wrong, they will resolve the dispute in arbitration, not in a state court. If this clause is written clearly and correctly, it basically opens the door to ICAC. If it's vague or incorrect, things can get much harder later. In that clause, parties can also agree on things like the language of the proceedings, the number of arbitrators, and even the applicable law. So a lot is decided before any conflict even happens. Now, let's imagine a dispute has already appeared. The first real step is preparation. Before filing a claim, the claimant usually gathers evidence and checks whether there was a requirement to try negotiations first. Sometimes, contracts say that parties must attempt to resolve the issue amicably before going to arbitration. At this stage, it's also very common to involve legal professionals who specialize in international arbitration. This helps avoid mistakes and saves time later. Then comes the statement of claim. This is the document that officially starts the arbitration. It includes details about the parties, a description of the dispute, legal arguments, supporting evidence, and the value of the claim. Even if the claim is not about money, its value still needs to be determined. After the claim is filed, the proceedings begin. The claimant pays the required fees, and the respondent has 30 days to submit a reply. They can also file a counterclaim if needed. Next is the formation of the arbitral tribunal. In most cases, there are 3 arbitrators. Each party selects one, and the third acts as the chair. In simpler disputes, a sole arbitrator may be appointed. A key principle here is impartiality. Arbitrators must be independent and have no connection to either party. Once the tribunal is formed, the case moves to hearing stage. Hearings can take place in person or online, and in some cases, the dispute is resolved based only on written submissions. During this stage, both parties present their arguments, provide evidence, and may involve experts or witnesses. The process is confidential and generally efficient, often completed within a limited time frame. There are also additional possibilities, such as combining related disputes into one proceeding or involving third parties, if all conditions are met. Finally, the tribunal issues its decision, the arbitral award. This document includes the reasoning behind the decision and the final outcome of the case. Once issued, it becomes binding immediately. Usually, parties comply voluntarily, but if they don't, the award can be enforced through national courts in different countries, which is one of the major advantages of international arbitration. So, overall, the process follows a clear sequence: agreement, preparation, filing a claim, forming the tribunal, hearings, and a final binding decision. And while it may seem complicated at first glance, with the right approach and support, it becomes a predictable and smooth process to solve international disputes. That's exactly what we focus on: helping businesses navigate arbitration smoothly and reach practical results. Thanks for watching. And if you'd like to understand how this works in your specific case, feel free to get in touch.